because we have a lot of events that we could talk to you about. I want to introduce Chuck Cagle, and and it's almost unnecessary because I don't think there's anyone. When I just put Chuck Cagle's name on a an introduction notice saying we're going to have Chuck Cagle these days, it'll fill up within a couple of minutes. So, Chuck, I'm not going to take any more of your time. I'm going to welcome you, and I'm going to let this be the Chuck Cagle show for the next time. Just remember, you do need to give them a break at some point in time, and I'll try not to interrupt you.
I think I saw Michelle Simcox join. Michelle, if you're able to talk, how are things?
They're actually, hello everybody. We're actually very blessed as a community. The support that we've received across the state has just been overwhelming, and we appreciate and thank you all for all your prayers and everybody that has contributed. We still have about 30% of our county without power and water. There's only one way into our county because the other ways leading to North Carolina and Virginia, the roads are completely gone. We have several homes, families just gone. I mean, their houses are gone. And it is just very, very sad. But in times of sadness, there's always hope. And that's what we're feeling right now. So just please continue to remember all of us in Upper East Tennessee, especially Carter, Johnson County, Carter, Unicoi, Cott County, parts of Greene County. We're still just very devastated, and just appreciate all your thoughts and prayers.
We're so happy to have you, Michelle. Glad you could be here.
I was a little bit surprised to see you log on. So thank you for the update.
I can't miss a day with Chuck.
I was one of those folks who was pretty much under the concept that there's not 2 acres of flat property in Johnson County, but apparently there's some property up there where water can accumulate, and it really is devastating what happened. And we're glad you're here, and I hope we'll keep on supporting everybody. So it's good to have you. Today's program is going to be a little bit different from what we usually do here. There will be a handout that's produced. There's been enough mischief and odd events go on this fall that when I sat down to do a handout, I just ran out of time for having to answer superintendent's questions on the phone and otherwise. So we're going to produce a handout for this. But I want to have I think that for right now, the conversation is about policy in particular is a little bit more important than maybe the handout. And because I want us to forget the writing for just a minute. I want to open this up to a general discussion about policy, and I have some things upon which I'm going to focus with regard to policy. But I want us to have a more general discussion about what policy is, how do we get it, where did it come from, why do we have it, is it important? Is there some reason why we have this thing called the policy manual? And then what happens if you just throw it out the window? What happens if you just ignore your own policy? So we're going to have a discussion about policy. For those of you who happen to be on here who have been through my new superintendent's orientation. One of the things that I tell the new superintendents that you have to have access to several documents. You need access to somebody who either a copy of the law. You need to know where it's located on the internet. You need to know your school board lawyer's name and phone number in a hurry. But you need access to somebody who can tell you what the law is. There's some place where you can find the law. The second thing is you need access to, and that includes federal and state law. The second thing is this whole body of regulations that we have, both the state board regulations and the code of federal regulations. You need somebody who can tell you where that's found and what you have to do according to federal regulations, because the federal regulations are the guidelines for how we implement federal law. And the same is true for the state board regulations. They're the guidelines on how we implement state law. The third thing is that I recommend for them is their board's policy manual. And as I told the school board last week, when I was in a meeting with them, when the superintendent calls me, one of the first things I do is say, "What's your board policy?" They ask me a question, and I said, "What's your board policy on that?" And while they're looking it up, and I pull it up on my screen, and usually because most of the policy manuals are published now online. My question to them is, well, why wouldn't we follow the policy here? Let's just follow the board's policy. That is always a safe a way to go. And then the fourth thing is if you have some sort of collaborative conferencing agreement, and if this is an employment issue, we have to reference your collaborative conferencing agreement if you have one. So those are the four things that you need access to. The policy manual being a very important part of that. Imagine, if you will, being in a hearing and a lawyer who is against the school board holds up the policy, and you're in the witness chair, and they say, "Is this your board's policy?" And you say, "Yes." And your policy says you must do this. Did you do that? And your response is no. Well, the policy then becomes, well, why not? Why didn't you follow your own policy? So that policy manual is a very important thing. And again, I'm going to cover 3 or 4 areas that are pretty hot topics these days about policy, but it's a very important thing to know and to follow. And it's one of the things that we ought to consult immediately, particularly in a case where there's damage. Did we follow safety policies? Did we follow safety regulations? Lawyers sometimes ask the question of why wasn't there a policy? And I'm going to go into that just a little bit. If you don't have a policy, there's nothing that says you have to have one, on a lot of things. In fact, if you only had the policies in your manual that are mandated by statute, you probably have fewer than 50 policies. I went through one time and counted all of them. It was 27, 28. I think there are a few more that have been added now. But you would have a policy manual that is just that big. But policy manuals have to be bigger than that to give guidance on such things as student discipline and employee suspension and employee rights and things like that. So they have to be a little bit bigger. The importance of policy came about several years ago in a case nobody ever heard of. And I've mentioned it 4 or 5 times in presentations that I've done. The reason I remember it so well, it was written by the judge who introduced me to the bar when I passed the bar exam. Judge Herschel Franks wrote a dissenting opinion that became the law of the state. And that's a pretty rare event in Tennessee for a dissenting opinion for a judge on the Court of Appeals to be actually adopted by the state Supreme Court, and it became the law of the state. We have to get into some topics here that get into the weeds of legal jargon a little bit, but I'm going to try to stay out of it as much as I can. The case that I'm talking about is Bowers versus the city of Chattanooga, and this actually involved the Chattanooga City School Board. And that goes back a ways for those of you who may not on the line, who may not even remember when Chattanooga had a city school system. But I'm very familiar with this case and with this set of incidents and with the Chattanooga City Schools when they existed. The case is reported at 826 Southwest 2nd 427. It's a 1992 opinion by the Tennessee Supreme Court. In this case, involves a policy consideration by the Chattanooga City School involving transportation, the transportation of students, and they adjusted some routes for transportation. And Danny Bowers was on a school bus that was involved in the adjustment of routes and the adjustment of spaces where children were let off. And it's right in the middle of Chattanooga. It's on Dodge Avenue in Chattanooga, Tennessee. And I know where Dodge and Macaulay Avenue are. They're very busy thoroughfares. Well, this particular day, the route had been adjusted Danny Bowers was put on a different bus. That bus stopped at a different time than it usually stopped at a daycare center. Danny got off the bus. He was usually met there by his mother or grandmother. And of course, the bus being early because he was put on a different bus that stopped at a different time. His mother just arrived and tried to stop him from crossing the street. Nevertheless, he crossed Dodge Avenue and was struck by a car after disembarking the bus. Chattanooga claimed what was then called discretionary function immunity, saying that we're a governmental entity and you really can't sue us unless you can show how we have violated some form of discretionary immunity, or how that reaches into a personal decision, and the analysis goes on and on there. I don't want to get lost in the analysis of discretionary function immunity, but in his dissenting opinion at the Court of Appeals, Judge Frank said it's time for discretionary immunity to be revisited. And the state Supreme Court under Justice Galota actually did revisit discretionary immunity. And they said that there are certain functions for which a government is immune from any liability under vestiges of discretionary immunity. And then there are certain things for which the government is not immune. And of course, we have the Governmental Tort Liability Act in Tennessee that gives citizens the right to sue the government for errors that the government creates. So this is sort of the beginning of the reform of discretionary immunity. So what kinds of things are you immune from? Let's say you get into a bit of litigation, and the lawyer says, "Well, why don't you have a policy?" Well, does the statute say that you must have a policy on something? I mean, go through your policy manual. You've got several hundred policies there. Pick one. There's some authority for policy, but does the statute actually say you must have a policy? And in many cases, you don't. You just don't. The policy describes how we're going to treat a situation, but the statute does not require a policy. So the fact that you don't have a policy on something that's not required either under federal or state law, you have discretionary immunity function, discretionary immunity for that. It's the operational test, the planning and operating, the planning side, and the planning operational test. The planning side is the one where you would find some immunity. Now, take for example a subject that we're going to discuss, like Title IX. Title IX requires you to have a policy. Most Title IX policies that I view candidly are mostly adequate, as we would say in Sweetwater. They're mostly pretty good. But in a lot of cases, these policies leave out very important things that are required by the federal regulation. And as a note here, I'm going to say this a couple of times. Tennessee is one of those states that is immune from enforcement. Is not under enforcement of the 2024 Title IX regulation. There are 27 of those states. And our district court has said that Title IX, the new regulations don't apply here. So we're still under the old regulations. And even the old regulations state you must have a Title IX policy. So if you get a lawsuit that claims a Title IX violation, and they ask you to look at the policy, and when you look at your policy, and either you don't have one or it's wholly inadequate, you may not, that's the operational side of this test, you may not have immunity. That may inure against your good standing in such a case. If you have either no policy or a wholly inadequate policy on Title IX, a policy that you can't defend. So Danny Bowers, the case of Bowers versus Chattanooga, changed a lot of things that we do, a lot of the way that we think about policy, a lot of the importance of policy. And again, as things happen, and I get calls from superintendents and principals and other folks, usually one of the first questions I'll say, what's your school board policy? What does your policy say? Now, thanks to our colleagues at PSBA, a lot of people's policies are pretty much alike. They're tailored to meet specific instances in school districts, depending on grade configuration or the type of school district that you're operating, and there are several different types. But most of the policies, the basis of that policy, if you subscribe to that policy service, the underlying bones of that policy will be the same from district to district. You're allowed to tailor those to your specific needs, and many of you do.
Chuck, before you go on, your microphone broke up just a little when you were telling us the name of that case that you were talking about in Chattanooga. Could you repeat that for our
Sure.
audience?
It's Bowers versus the City of Chattanooga. BOWERS. It's 826 Southwest 2nd, 427. Cases, the opinions, the dissenting opinion at the Court of Appeals was written by Judge Herschel Franks, who is a good friend of mine, and I worked across the hall from him for 3 or 4 years. Then he introduced me to the bar when I passed the bar exam. The Supreme Court's unanimous opinion was written by Justice Frank Garota from Nashville, and it changed the law. It overruled literally 20 years of jurisprudence on discretionary function immunity in Tennessee, and the focus of this was on policy. Particularly a policy out of the Chattanooga City Schools that spoke about transportation. The other thing that's important about policy is, and by the way, Wanda is monitoring chat. So if you have questions, put them in chat. Wanda breaks me up every now and then, tells me to take a breath, and she asks me a question. That's the way this works. So put your questions in chat. Feel free to ask as many questions as you want. The other important point about Bowers v. Chattanooga is, besides stressing policy, I think it says that if you have a policy, you're expected to follow it. You're expected to follow it. And the third thing that it stresses in Bowers v. Chattanooga is that if you don't follow it, some liability is going to attach. So your policy becomes very, very important. Now, the one thing that we say all the time as lawyers, as counsel school attorneys, to anybody who has a policy, is if you have a policy, then it's incumbent upon you to publish that policy. It just can't be hidden. And of course, the statute requires you to either publish your policy and have a copy of it in your library, or publishing your policy on your school system website is considered publication of policy. The populace can go there, take a look at your policy manual, and know what the policy is. And I get questions all the time from superintendents where a parent has gone on, reviewed the policy, and said, "Well, that's my interpretation." Here's it's my interpretation that you violated your policy. Here's another very important point about policy. And if there are school board lawyers on here, they've heard me say this before. It doesn't matter what I think about your policy, but I'm going to look at it. I'm going to say that every word in the policy means exactly what it means. So I'm going to look at it facially and just say your policy means what it says. Clear and unambiguous language in your policy is defined. But if somebody is trying to give it a bit of an odd interpretation, say, "Well, that's not what this policy says. To me, this policy says this." The final arbiter of what your policy means is the school board that adopts it. Now, I have had the opportunity to be in school board meetings where I've looked at a policy. I've said, "It's my opinion that this is what your policy says." And school board members have said, "Well, we disagree. We disagree." I'm getting an odd signal here, Rhonda. But I've had to be in meetings with clients where they have said, "No, that's it. For us, our policy means this." And I have to yield to the school board's interpretation of it. The final arbiter of what the policy means is the group that created the policy, and that's the school board. So if there are school board members who are in attendance today, and you're trying to give a rather strained interpretation of your policy, that's probably not going to hold up. The policy means what it says. Hence, review of policies on an annual basis is very important.
And
Very
the notice you had was that closed captioning went on because there had been a couple of minutes where your mic was not as clear. So it's closed captioning for the people to catch you in case something isn't clear to them.
I hope most folks will find this funny. The notice that I actually got was the one that said it sounded like I had changed languages, and they wanted to make sure I was still speaking English. I'm speaking East Tennessee English, so AI may not have picked that up. So that's the way it is. At any rate, the final interpreter of policy is the party that created it, and we run into that all the time in cases in front of administrative bodies here in Nashville. So, not many of you may not know that I have occasion to represent professionals in front of licensing boards or agencies in front of licensing boards in the state. It's all a matter of administrative law. And the problem that we have is we'll get into a licensing board and they'll say, well, that policy doesn't mean what it says, it actually means this. And I just raise my eyebrows and go, I think I'm pretty familiar with the English language. I looked up most of these words that I didn't know. Why is it that you're giving it this meaning when the policy doesn't say that? So we fight these battles not only at school boards, but in front of boards like the doctor's licensing board and the pharmacist licensing board and the dental licensing board, architects and engineers licensing boards, and things like that, because they want to lend some sort of odd interpretation to their policy. Courts don't like that. Courts don't like it, even though the final arbiter of that policy, it generally is the body that created it. Courts don't like that. Courts are like that you interpret your whatever decision you're making according to policy, that every word in that policy is given its ordinary meaning. So policy, the writing of policy is an art form. It is literally an art form, and the people who do that, that is a very marketable skill, and particularly when you get to something like Title IX, because the new regulations for an act that has 39 words in it. How many of you knew that Title IX consists of 39 words? That's it. There are 1,600 pages of regulation that go along with those 39 words. That writing the regulations is truly an art form, and people make their living on it in Washington, D.C. And in other places in Tennessee, writing state board rules, things like that. Your policy is very important. I can't stress how important policy is to the function of school. And again, take a look at a policy. My one admonition, if you're taking notes, my one admonition is if your policy just repeats the law, that policy is unnecessary. We're going to go with the law trumps policy. You cannot have a policy that contravenes the general law. You cannot have a policy that contradicts law. That's not allowed. The policy should explain the law and how you're going to enforce that law in your the requirements of law in your system. But the policy cannot be contradictory to what the law is in Tennessee. And sometimes we have to balance that. So annual policy review is necessary, and the third part of this program today, you're going to find out that policies have to be reviewed annually because the laws change annually. The laws change annually, so you're going to have to go through your policy manual to make sure that your policies aren't contradictory to law because the law has changed. Dr. Lilly and others, and went across. I was part of the team that went across the state explaining to superintendents what the changes in the law were. The Tennessee School Board Association has done that. Several agencies have done that. And we have policies all over the place in every section of the manual that are going to have to be changed as a result of new public chapters that have been enacted by the General Assembly. Bowers versus the city of Chattanooga reduces an action of an agency and the school board would be considered an agency under this law, to whether it's planning or operation. And sometimes there is immunity for the planning side, and that's the formulation, for example, the formulation of policy. There is immunity for that under the law, but when you get that policy published, that goes into the operational side of it, and you're expected to follow it. You're expected to follow it. If you don't follow it, your immunity from liability under the Governmental Tort Liability Act may disappear. So that is a very, very important thing to remember. Any questions about that at all, Wanda?
I don't have anything in chat.
Okay. So we're going to go to the first and one of the most important things that we do. And this year, for some reason, my telephone just will not stay on the hook because of Title IX question. This has been a year like no other for Title IX, both at the K-12 level and at the university level. We're inundated with questions about Title IX. And of course, Title IX policy is depending on what state you're in now, is either governed by the 2024 Act or the 2011 Act, and as the regulations were promulgated to support that act, the revisions to it. So we're busy trying to. When somebody calls me, I just say I'm thankful I'm in Tennessee. I haven't had to learn the new regulations yet. Editorially, if the 2024 revisions come into place, folks, we've got a lot of work to do. We have a lot of things to do with regard to Title IX. So just be aware of what's going on. Well, Title IX is again, as I said, it's a 39-word act that was enacted in 1973. Put in the chat, the first person to put in the chat the correct answer, what president signed it, and if you get extra credit, you know the senator who sponsored it. But 1973, that should give you a hint. That's how old the act is, and it was. It says that Title IX says that you can't discriminate. Any program that receives federal dollars cannot. Ms. Brown wins, at least it was President Nixon who signed it. And the person who gets the Senate sponsor of it wins Gary Lilly's first door prize. But anyway, it's the act says that any program that receives federal dollars is entitled to must not discriminate on the basis of sex. There is a United States Supreme Court case on Title IX because the several colleges and universities challenged Title IX, saying that we don't get federal financial aid dollars. We don't accept federal financial aid dollars. And the U.S. Supreme Court said, no, it's any federal money. If you accept federal funding, you must enforce the provisions of Title IX. In public school, and including public charter school, if you receive any federal funding, and I don't know anybody who doesn't, any federal funding at all under that interpretation, then that would include federal school food service funds. Then you are required to enforce the provisions of Title IX in your school district. Again, they took a 39-word act and turned it into about the old law, about 1,100 pages. The new law, about 1,600 pages of regulations, which are very, very prescriptive. Well, what are the policy implications for Title IX as far as the local policy is concerned? And I want to go over a checklist that I found several weeks ago. And it goes into things that you should remember in adopting a Title IX policy. And again, Title IX is one of those things that under a case out of Gwinnett County, Georgia, that if you found guilty of a Title IX violation and it involves sexual harassment, you're subject to money damage. For violations of Title IX. Now, not in every case, but in that particular case, Franklin versus Gwinnett County, the U.S. Supreme Court case, that the money damages are available under Title IX for violations of Title IX. So this is a checklist for policy on Title IX that I found, and I thought it was really quite good. The first question is, has your institution adopted a policy stating it complies with Title IX, which prohibits sex discrimination, including sexual harassment against students and employees? Has your institution adopted a policy? That's question number one. And the answer is, if your answer is no, you and I need to have a chat, because you are required to have a policy that says that. That is a requirement of the federal law. The second question that it asks is your institution's policy published on the website? And that is also a requirement of Title IX, that you publish the policy and any and all forms of publication that you have. The third is your policy published in handbooks and catalogs provided to students and employees? A student handbook or employee handbook, or if you have a catalog generally refer to colleges, is it available? Is it available for applicants who are working? Can they get a copy of your policy? Can they know what it is? Can any professional in the district pick up a copy of your policy? And that's a very important point. Have you adopted a grievance procedure, or have you adopted a complaint procedure under Title IX? And is that published? Well, again, that's a requirement of federal law. You have either a grievance procedure for employees or a complaint procedure. You can call it a complaint procedure in both instances, if you will. But is there a procedure for filing a Title IX complaint? And does that procedure include the filing of a complaint, particularly in a K-12 school, the filing of a complaint by some employee who knows that harassment or discrimination is going on that involves students or employees? So a third party can file a complaint if employed by the district. So just be aware of that.
And Chuck, does published, do you have to have a hard copy, or can an online manual work?
An online manual is fine. And it's, I know of, I represent K-12 schools, obviously, but I represent universities, and one university with which I'm familiar, that's their only catalog is online. But you should publish the website with the catalog. I mean, if you're not going to publish the policies in hard copy, make sure that the access to such policies as Title IX is very prominent. But you let them know where it is, and so that they can access it and follow it. I would always be willing to, as an educational institution, download a copy. There are a certain number of folks out there who don't subscribe to computer use, who are not familiar with it, or they may not be familiar with the internet. I would always, if somebody has a complaint and they say, I don't have access to the Title IX policy, I would be very willing to download that. I would advise you legally to download that policy, give it to them. Just send it to them any way you can, either in U.S. mail or hand them a copy of it. Any other questions? Okay. So does your institution have a grievance procedure under Title IX? And is it being followed? If a grievance is filed, we can't under the Davis versus Monroe County case, which is the U.S. Supreme Court case. It's not Monroe County, Tennessee. It's Monroe County, Georgia. Under the Davis v. Monroe County case, we can't show deliberate indifference. We just can't say, well, we'll get to that when we get to it. No, if you get a Title IX complaint or a grievance, it sort of takes precedence over a lot of things on your desk right now. So we can't show deliberate indifference about starting the investigative procedure. And deliberate indifference is not a term that I just made up sitting here. That's actually in the court opinion. Yeah, the school system cannot display deliberate indifference in handling, either addressing or handling a Title IX complaint or grievance. So it does take some precedence over what's going on in your office that day. Any questions about it so far?
I do have an email question. If there's a confusion about a policy, can the board meet to discuss how they want to proceed?
There's a couple of ways to do that. Number one is if that incident, whatever it is, has risen to the fact of or risen to the level of a controversy, for example. I can take, as a lawyer, I can take my client into executive session and say, here's the issue. There may or may not be a lawyer on the other side, but litigation could arise out of this. How do you want, what is your interpretation of this policy? Now, client, board, this is my interpretation. What is your interpretation of this policy? And usually, if there's no ambiguity in the policy, then I advise a client in such an instance that go with the language of the policy. If there is ambiguity, I think it's incumbent upon me to look at the board and say, this policy has some problems, and I need to know how to proceed in this and with this, and how to advise the principal, how to advise the superintendent in this matter. So that's what we would do. Yes, boards can either take it up in public session and say, this is our official interpretation of it, provided there is some ambiguity. If there's not any ambiguity, it's always going to be my advice that the policy means what the policy says. Because I can't go in there and lend a real crafty explanation of the policy to a judge when the policy literally is pretty clear. The next question that is that's raised by on the website that I found several years ago looking at Title IX policy is, has your institution designated and given necessary authority to at least one Title IX coordinator? That's a very important issue. And I never thought about giving authority to a Title IX coordinator. So this is all in your policy. It's I deal with a lot of more of this on college campuses than anywhere else. And when let's just use an office, for example, if the dean of students or an associate dean of students is the Title IX coordinator, and that person goes to question a professor or somebody else, that professor better understand that the Title IX coordinator has the authority to ask those questions and to demand answers. And your Title IX coordinator in your central office or wherever that person is in the K-12 school system is the representative. And I'm going to get this very clear. The Title IX coordinator is the representative of the Board of Education. Now, they may be employed by the superintendent, they may work for the superintendent, but they are the representative of the Board of Education in the Title IX investigation. And that Title IX coordinator has both the authority, or should have the authority, to ask questions about an alleged Title IX situation. And I'm just going to say it the way it is, and to expect answers. And nobody, no school system employee, literally no student who is involved in a Title IX complaint has the right to look at a Title IX coordinator and say, I'm not going to answer this stuff. That's not contemplated under the federal law. Your Title IX coordinator has both the authority and the ability to ask questions and to expect answers to those questions. And the Title IX coordinator literally is a representative of the Board of Education in those instances. Now, if somebody who doesn't want to give an answer, they say, I'm not going to give an answer, maybe we might want to explain insubordination to that person. It has a definition in 49.5.501. So we may want to explain insubordination to them, but they're required to give answers and not be evasive with their information. So giving a proper authority to a Title IX coordinator is very, very important. Does your institution identify the title coordinator by including their name and their job description, their office, where their office is located, and contact information? That's very, very important. A lot of Title IX incidents occur, in cases 12 occur off campus, they may be at a football game that's away, an athletic event that's away, some sort of contest that's away. The only consolation you have there is it must have occurred on American soil to be actionable under Title IX. If the incident that occurs is in France, Title IX doesn't apply. It just doesn't apply. Still, your Title IX coordinator's name and contact information should be very, very prominent. And I think most Title IX coordinators prefer, particularly for instance, incidents that occur on weekends, they prefer to have their email address so they can check email rather than, I don't know that I would publish a cell phone number. I would never make that probably a habit, but you do need current name and contact information for your Title IX person, and it needs to be published both to employees and for students. Does your institution prominently display the Title IX coordinator's contact information on its website? That should be there. Now, unfortunately, I've recently gotten involved in a K-12 incident involving Title IX, and when we went back and looked at their policy, Title IX coordinator was one that was designated 3 superintendents back. 3 superintendents back. Hence, the absolute need to review these policies every year and to make sure that that information is up to date. If you make a change in Title IX coordinator, that change should be made immediately. Because it's required under federal law. Does your institution's policy make clear that Title IX coordinator is the primary institutional contact for receiving reports of complaint of sex discrimination, including sexual harassment? Again, that's a requirement under federal law. The first place to stop is that office. Now, we do have case law that says that any teacher, any employee in the school system who becomes aware of this is required to report it to a person who has the ability to effect a remedy. Well, that's case law language. But still, that the employees who have knowledge of this have to report it to the Title IX coordinator. So that's the way this comes into the system, and that's the way we begin action, open a file, and begin action on the case, so as not to display again what the report referred to as deliberate indifference. Make it clear that if there is a problem involving harassment or sexual discrimination of some sort, that goes to the Title IX coordinator. If your institution chooses to designate an employee as a responsible employee or a mandatory reporter who must report to the Title IX coordinator, does your policy explain that requirement? Well, the answer is it should. All employees, so here's the language, all employees who have knowledge of an incident or act that involves Title IX should be reporting this to the Title IX coordinator. The next question, does your institution's Title IX policy explain that under ed regulations, it must respond in a manner that isn't deliberately indifferent when it has actual knowledge of the harassment? So again, these complaints take some precedence over lots of things that may be on somebody's desk. That they are not routine, and you can't. A lot of us have the habit of taking things as they come in and putting them in a line. And my habit around here is before scanning things, put them in a stack. When I get to it in stack, that's when it becomes important. That's not the way it is with Title IX incidents. They do take some precedence over things that may be on your desk. Does your institution's Title IX policy incorporate the definition for actual knowledge? And how is that transmitted? What does it mean to have actual knowledge of something that goes on? Is that a rumor? Well, no. Well, is is it something that's being talked about on a regular basis to the point that it's taking on sort of a life of its own? The answer to that question would then be yes. You need to get that to the Title IX coordinator for some review and questioning. Does your institution's Title IX policy incorporate the definition of sexual harassment on conduct on the basis of sex? That includes the following: quid pro quo harassment, hostile environment harassment, or sexual assault, dating violence, domestic violence, or stalking. Does your definition of sexual harassment include those things under your Title IX definitions? And if not, it should. One of the most interesting presentations I've had to make recently was to a church staff on the requirements of sexual harassment reporting and what the law says about it. And folks, let me just tell you that you don't get to say the word sexual harassment in church a lot. That's just not something that happens. And when you start talking about it among staff members of a church, or rather large church, then it takes on a different context. But no institution is immune from this occurrence. No institution is immune from it. When we get the cases that are filed in Tennessee every day at our office, electronic reporter pops up. It's an amazing number of sexual harassment in the state and the different types of industries that are involved. So it's not only schools under Title IX, it's employers of all types under other titles of the law that have to deal with it. Well, what is the definition? Does your policy incorporate the different types of harassment that there are? Does your institution's Title IX policy incorporate the definition of the educational program or activity? So the answer is it must do that. And that's things that occur both on campus and at school-sponsored events off campus. But the one limitation that we do have on Title IX is it must occur on the United States soil, on the property or some property in the United States, or it's protected. That's the only limitation that I know of. Does your institution's Title IX and policy incorporate the definition for deliberate indifference? As it should. We're not going to delay the investigation of certain things, but this is going to move up in priority among the things that we have. Does your institution's Title IX policy define a complaint or a complainant as the person who has allegedly been subjected to possible sexual harassment? Does it? There are two parties in a Title IX complaint. The one is the complainant, and the other is the respondent. It's not plaintiff and defendant. It's not plaintiff and defendant. It's complainant and respondent under the law. So do we define the parties accurately according to the requirements of the federal regulation? The complainant is the person who has filed or who is the victim, the alleged victim of some sort of discrimination. The respondent is the person who's the perpetrator. It's that simple. Does your institution clearly define consent sexual activity and apply that definition consistently, including the relations between all sorts of parties? Consent is one of those that you may not have in your policy. This generally applies more to colleges and universities, where the Clery Act applies. Again, if everybody's familiar with the Clery Act, that's that federal act that says that for all sorts of crimes that occur on campus, we have to make a report to the U.S. Department of Education and other agencies. So this applies more on college campuses, but you may want to have some reference to consent in your policy because students in high schools date. Now there are rules. Let me just say this: there are rules against teachers. There are laws against teachers dating students in school. So if that's occurring, that's a problem. That's a problem. But consent may be one of those things we want to define in the Title IX policy. And it says between students, there's references between students, between employees, consent between employees would be something very important to have in policy. And then between employee and the student, well, under the rules of ethics, under 49.5/1001, that can't occur. That cannot occur. If that occurs, that's going to be problematic upon its on the very instance of it happening. So just be aware of it. Harassment not covered by Title IX. As your institution determine whether it will prohibit sexual harassment that doesn't fall under Title IX, because even if they're true, it's not severe, pervasive, or objectively offensive. That's the title. That would fall under Title VI. And does your institution then have a Title VI policy that says even though it doesn't meet the requirement of Title IX, it's still actionable under Title VI? Well, you bet. You need that policy that says if it doesn't fit this definition, we reserve the right to move it to Title VI. And that involves students as well. It occurs outside the institution, education's program or activity. We get a lot of phone calls alleging activity that occur outside school hours. Parents come into the school, they forward these things to us, they say this is happening, and we have to have a good idea by policy of when it's our problem and when it's not our problem, when we have jurisdiction to cover it and when we don't have jurisdiction to cover it. And we need to, our policy should be very clear there that we look at a parent and say, folks, with all due respect, this is something that's falling outside of school. It's not had any disruptive activity or effect at school. Our policy says that it's not our problem. It's not something that we can address. We don't have jurisdiction. Wanda, I heard some.
I have a couple of questions.
Okay.
One, our policy says something about every staff member has to be trained. Who's responsible for that?
The school board is required to do that, and it can be done through any of the number of sources, through programs like this online. It can be done through, we've done several Title IX presentations for school districts. That's a popular way to do it. Going to national seminars of all types, where Title IX is a question, but the annual Title IX training is required.
And so that has to be in the policy, right? Yeah. And then the next question is, the bill sponsor, was it Mink? That was the first answer.
Senator Representative Meek from Hawaii sponsored it. The first person of color to serve in the U.S. House of Representatives, first person of color, a female, serving the U.S. House of Representatives, was the House sponsor. Birch Bayh from Indiana was the Senate sponsor. Birch Bayh was also the Senate sponsor for the Equal Rights Amendment. As a matter of history, he agreed to sponsor both of those because his wife had been denied admission to the University of Virginia Medical School when she applied because guess what? They didn't admit men to a graduate college. So he agreed to sponsor both of those acts, and it was gone down in history for passing one of them, Title IX.
Thanks.
I think the story behind some of these acts, the reason I do that is just as important as the act itself. What caused it? And as we in the law are so fond of saying, bad facts make bad law. And when you have universities, public universities, who were denying admission to women just based on sex, somebody's got to figure out nothing good is going to come of that. And Title IX is what came up. And its Title IX, of course, has been expanded into much further than I'm sure Birch Bayh ever thought it would be, or the Representative Mink ever thought it would be. Two very courageous members of the Congress took this on and actually made it work. Again, sexual harassment not covered by Title IX. One of the very important things is it occurs in a study abroad program or otherwise outside the United States. When we send students on these trips to outside the continental United States or outside territory of the United States, folks, it's my opinion that when you have the parent meeting involving that trip, you need to inform parents that certain acts that may occur on this trip are not covered under federal law. They're just not covered under federal law. And we've had to address that both at the K-12 level and at the collegiate level. That for Title IX to have application, it has to occur on on American soil. Now, let me make a quick distinction here. That doesn't mean that your school rules don't apply. Your school rules on the behavior and conduct of students on official school trips do apply. It doesn't matter where they are or what time zone they're in or what nation they're. So if they're on an official school trip, your school conduct rules still apply, as long as the school sponsored that trip. Title IX doesn't apply. Title IX doesn't apply. So let's make that very clear. Student can still be punished by the school, but it's not a violation of Title IX if it's outside of the American soil. Anybody got a question about that? I want to make sure that's very clear.
I don't have any questions.
Okay. And again, you should have a policy that applies on student conduct. If you're going to take one of these trips, particularly out of the continent, off American soil, then you should have a release form that a parent signs and say where the parents understand that the school disciplinary rules do still apply as long as this is a school-sponsored trip. And that's often the first decision that I have to make as a school board lawyer: is this a school-sponsored trip? And I'll give you an example of one that's not. We have teachers who work for travel agencies who take trips during spring and fall break and summertime, and they get their trips free, and there are all kinds of deals that are worked out. If that trip is not sponsored by the school, then our conduct rules don't apply. If it's a teacher who's working as an agent for a travel service and has put together a trip to Norway or someplace like that, and it's not school sponsored, then that's not our game. That's the teacher may be held personally liable for it, and that's what we tell the sponsor, or if it is a teacher. But that's what we tell that person: you may be liable for it, or your travel agency for whom you work may be liable, but we're not. We're not. So let's make a decision about who's sponsoring the trip. That may be a need to address in another policy about privately sponsored trips for which school students are recruited. Does your institution state that exercising First Amendment rights doesn't constitute prohibited retaliation under Title IX? The students have a right. We'd like to keep Title IX complaints confidential, but sometimes the complaining party in the case, they want to go out and talk to the media. We can't stop that. We can't stop that. And sometimes they do go out and say, I was the victim of some sort of assault or something like that. It's been turned over to the Title IX coordinator at the school. They get on social media, they talk about it. We can't stop that. We can't stop that. So we can't put it in your policy that confidential means confidential. We'd rather they remain confidential, but if they decide to get on social media or go talk to members of the press about it, we just can't stop it. Does your institution make it clear that a person won't be charged with an additional code of conduct violation if it arises out of the same set of facts or circumstances, if a charge is for retaliatory purposes of interfering with the right of the title? Now, what we do, let me just rephrase that another way. What we do is state that there will not be any retaliation taken against a person for reporting a Title IX violation. We take no retaliation. We take no retaliation against a student who's accused of. So we don't retaliate against that student. And we've got to go through the investigation before we go through the discipline. I don't know I hope you're aware of that we don't discipline first and then do the investigation. We have to go through the Title IX, we go through the investigation first and then discipline. And there are services that we have to provide, but we don't retaliate. We don't retaliate. taking action against a student for making a false complaint of harassment or, abuse is not retaliation. I'm going to say that again. Taking action against a student who falsely reports an alleged Title IX violation is not retaliation. That, ladies and gentlemen, should be prominently prominent in your policy and should be in bold letters. If it's determined that the complaint was, the complaint was made and it was false, and it was made falsely in bad faith, then we reserve the right to punish the student who made that. Because why is that? Well, because number one, it's lying. But number two, you spend a lot of time and energy just in school time just to determine that there's no basis in fact for making that complaint. So taking action against a student who makes a false claim of a Title IX violation is not retaliatory. That's not retaliation. That's in anticipation of that. To protect the potential for retaliation, do you protect confidentiality? The answer is yes, we do. Students may go out and talk about it. Their parents may go out and talk about it. They come to the school. We don't talk about it. It is a student record, and we will not talk about it. It is confidential as far as we're concerned, and we will have no comment about an alleged violation. That fact alone does not make the media very happy that we won't talk about it. But believe it or not, the media are smarter than they appear at times, and when we tell them we can't comment, it's not a surprise to them. It's not a surprise, and we should not hesitate to say that is a matter of a confidential nature under federal and state law, and we can't have any comment. That's it. They'll still try to get to you to see if you're having a weak moment, and will comment. Don't falter. Does your institution state that complaints of retaliation are addressed under the general Title IX grievance procedure, and they have an equitable resolution? Now, again, that's a lot for colleges. But if somebody makes a complaint of a Title IX violation, and then we end up retaliating against that person, that's going to be against them. So there should be no retaliation whatsoever for a valid claim of Title IX complaint. I saw questions coming.
Yes, I have a couple of questions. You got people all wrapped up on here. We allow teachers to advertise EF, educational tours, in our building. Does this mean that they are school sponsored trips? And no. So okay.
Now,
and
let me answer that more fully. Folks, that's dangerous. Let me just tell you that's dangerous, because if a teacher is acting as an employee of a travel agency and somehow they advertise a trip to Scotland on school system equipment, what you've done is turn that school system equipment into an open forum, which means that Chuck Cagle can come down there and advertise on the school system's equipment his law practice. If I represent a plaintiff, it means that any travel agent can come down and advertise their trip. It means that any business can come down and advertise their business. Joe's Gym, A&W restaurants, whoever it is can come down. Once you turn your school systems, your school systems into an open forum, anybody gets to advertise. Hence, if teachers are sponsoring these trips or taking these trips as agents of a travel company, they should just say, you need to do that through the mail. You just need to do that through the mail. You have access to, because of directory information, you have access to students' names and addresses. And if you want to advertise your trip to Scotland, then you can use students' names and addresses if you make a proper request to use them. You can use student names and addresses, but if you use school equipment for that, the answer should be no.
Now, the email question is this: we allow teachers to take those trips, but they have to get board approval first and agree to follow things like it says here, Tennessee drinking laws. does that cover us? Does that change things?
It complicates it.
Okay,
Again, folks, if this trip is sponsored by a teacher acting in their private capacity as an agent for a travel service, the school board has no jurisdiction over that. Now, are we giving credit for that trip? Then the school board has jurisdiction over it. So every question is fact dependent. But the school board, if you're not giving credit for this trip, if this is clearly just a trip to, and I'm using Scotland as an example, but trip to Scotland over the summertime or fall break or spring break, there's no credit being given for it. It's leisure time activity. Why in the world would the school board sponsor that? Because that could open the school board to liability.
and the follow-up question here, does that include, we have our 8th graders going to Washington, DC. It's optional, but the board approves that.
Is that's considered in most cases a school sponsored trip?
Yes, yeah, okay.
It's an optional trip, but yes, that would be a school sponsored trip. And
Yeah. The next question is, when you were talking about the press, I think I have this question right. If it's a teacher-student thing, at what point does it change from a Title IX investigation to a criminal investigation? And does that change when we can comment?
it's both.
Okay.
And it doesn't change. It's both. And if it's a teacher-student issue, there are 3 issues that are involved there. Number one, it may be criminal. And every time somebody says, I've got a teacher who's had a relationship with a student, it's almost a don't pass go, don't collect $200 thing. Report it right now to law enforcement and DCF. Start right now. The second thing is it a Title IX violation? Well, likely it is going to be. So you immediately notify the Title IX coordinator to start the investigation. And the third thing is the teacher ethical violation. So your personnel director is going to be involved in that. Now, or whoever investigates these for personnel issues, because it could be an offense for which a teacher is terminated. So we need to make sure that the rights of teachers under 49, 5, 10, 5, 11, 12 are all followed there if we're going to suspend the teacher. So it could be an HR problem, a Title IX problem, and a criminal problem. And we just have to wade through it. We have been involved here in a couple of cases where it's been all 3. And the law enforcement and the DAs, the district attorney general, tell us to stay out of it. Don't do anything until we finish our investigations. And I tell them I can't do that. It's not possible under federal law. It doesn't make them happy. But it could be, if you have a teacher-student issue, it could involve 3 or 4 things. So, we need to have a good, complete policy that says the way we're going to act with the Title IX violation in this particular instance. But we also have personnel procedures on the fact that the teacher is probably going to be separated from service. We have to report it to the State Board of Education if they've been suspended. So that's also a policy or procedure that we need.
And this is I'm not an attorney, but I will have to say, when you do all that reporting, even if your investigation proves there may not have been anything, it may take those other agencies much longer than you anticipated. So what's your role there if the DA is still investigating?
My record there's 23 months.
Okay.
We had a teacher who, in the school system I represent, that really was suspended for 23 months. And at the end of 23 months, DCS closed the case. They said there's no proof. By that time, I don't mind telling you, I had laid down my good Baptist upbringing, and I was pretty angry and let him know it. Because we had to pay that teacher 23 months of back pay for nearly 2 years of back pay, and the teacher immediately retired. Immediately. I had to come apart. As I'm so fond of saying, and I hope you take this as a joke, It's instances like this that just make you want to smoke and drink. But it's, it's frustration like we can't deal with it. We don't have the ability to tell another agency to speed it up. That we have decisions that we have to make that are dependent upon the decisions that you make.
Yeah.
And the whole time, this could cost us a lot of money, not only in the possible legal fees, but in back pay. If that person is reinstated, if they're vindicated and reinstated, the statute says you owe back pay.
It's thanks, Chuck.
Title IX regulations. Here's some bullet points. And again, we're going to produce a PowerPoint for this and post it on the top website. But things to remember: this designated Title IX coordinator to coordinate your school's compliance with Title IX, and we'll cite the federal regulation that says you must do that. And again, that Title IX coordinator, ladies and gentlemen, I'm going to say it again: they are a representative of the board. They have authority to ask questions and to conduct the investigation. Any employee who doubts that can be reminded that their refusal to coordinate to cooperate with a Title IX coordinator or investigator may be considered insubordination. Update your school's non-discrimination policy and notice of non-discrimination, and there are 2 federal statutory citations for that. Make sure that your non-discrimination policy is adequate. But first of all, make sure it's present, and then make sure it's adequate. Develop and or update the Title IX training in your school for all employees. And folks, remember when you're doing Title IX training, as I was reminded when I had to do training for church staff, you're speaking to classified staff in some cases that don't have advanced college degrees. So Title IX training or harassment training, whichever it is, in your policy, it needs to be delivered by somebody who has the ability to educate an audience, that literally has every educational background, all the way from maybe not even a high school diploma to PhD. So you have to get this message across to all of your employees. And your training is required, but that should be a consideration for it. Develop and or update the training, the training tailored for Title IX coordinator. Make sure that your Title IX coordinator is trained, and that any investigators that you have are trained. That is a requirement of statute. Update your school's record keeping practices. Particularly if you're a college or university, you have to update it according to the Clery Act. So make sure that your record keeping practices are up to date. Revise the grievance procedures in your school. Those should be revised occasionally. Again, that should be in your policy. Ensure your school's Title IX policies and procedures are consistent with everything in the federal regulation. That takes some doing. That takes some doing, and we're happy to look at your regulation, your policies, and tell you whether or not if you have a separate school board lawyer, your school board lawyer should sit down with your policy and make sure that it's compliant with all the requirements of Title IX. Make sure that your policy says that you're going to respond promptly. Again, the key word, deliberate indifference. Make sure your policy says you're going to respond promptly. I've even seen a school policy that says within X number of hours, the school system will do this. Within X number of days, the school system will do this. Now that took some planning on the part of, that took some research on the part of policy. But it says, their policy said within 6 hours of the receipt of a policy on the same business day, we'll start an investigation. That was the requirement of policy. So make sure your policy is complete with regard to how you're going to investigate the case. Make sure that your policy responds to the notice of the student or employee's condition. Where can they be located? And make sure that your school separates or treats individually. If your school separates or treats different individuals differently on the basis of sex in a context that Title IX generally permits, ensure that it does so in a manner that does not discriminate on the basis of sex, consistent with the law. In some cases, we can have programs still as we do in the state of Tennessee, athletic programs. according to state law where the sexes are separated. Make sure that your policy addresses that in a way that if somebody has a complaint about discrimination that occurs within a separate sex program, and it's possible for hazing, for example, to occur within an athletic team, be it all boys or all girls. Dealt with one of those cases last week, a hazing case. So let's make sure that in cases where we have separate programs that are separated by sex, that we still have Title IX still applies there in those cases. Anybody got a question about this? Any questions pending, Juan?
No, sir.
Now might be a pretty good time for a break.
Great.
Would you like to take one?
I would like to take one. Do you want 10 or 15 minutes? Up to you.
Let's do 10 minutes.
Okay, we'll be back in break is over.
Let me go back to the beginning and just remind everybody that one of the purposes, I think we have to go back and do a certain amount of reteaching in order to reach career level 3. Isn't that right, Wanda? There was a certain amount of reteaching that had to be done to reach career level 3 and the career level 4.
Yes.
Go back and remind everybody that the whole basis for all this is Bowers v. Chattanooga. A, do I have to have a policy? And then B, am I following it? And then C, what's in it? What's in the policy? The policy has. So Bowers in this case, using that case as the basis for what we're doing today, would say under the operational planning side of this, you must have a policy under Title IX. The law says you have to have one. B says also that if you have that policy, then you're expected to follow. And C, if you don't follow the policy, there's some pretty significant liability that can attach to it. So again, the planning operational side, planning being what is the policy? Do I have to have it? Operational side being how did I put that policy into effect? And that's that is the importance of policy and this discussion. And we're just picking out 3 or 4 things today that are very important based on regular and timely changes that I think that we talk about in the realm of the importance of policy. The importance of policy. The second thing that I'm going to discuss briefly. And by the way, if you have questions about the school trip thing, that's something else that we can discuss probably next Thursday in the miscellaneous section. If you have your questions are burning today and you need an answer, I'll be happy to answer them. But I found out the other day that a question, a statement that's popular among folks who are much younger than I. I heard this on the radio and laughed for the next 10 miles down the road, where some kid looked at another kid and about an issue, and this, they would come up between them. And the second kid, basically, in his way of saying I'm not concerned about that. But his way of saying it was, not my circus, not my monkey. And if the trip is not a school trip, then we need to say it's not a school trip. And we need to probably a clear policy on how we're going to deal with trips that are sponsored privately and trips that are sponsored by the school district. But we can't be responsible for everything out there. Now, what we can do, as I said, is turn the trip into our responsibility by getting board approval for a trip that's not ours. Why does the school board approve it if it's not ours? If we're not collecting the money, if we're not sponsoring it, if we're not appointing the chaperone, if we're not granting credit for it, why would the school board ever approve that? I would just say, you're on your own. This trip is yours and we're not liable for it. And if something happens, the true sponsor of the trip is liable. But that's one of those things that there are as many variations of as there are letters in the alphabet. And we just have to answer it on a case by case basis. Is it a school trip or isn't it a school trip? And what does that mean as far as policy and liability goes? The second thing that we're going to talk about today is briefly, because I'm going to talk about this on the next session on Tuesday, is interim alternative placements under IDEA. I see a lot of policies, a lot of school board policies on IDEA. The first one, let me just say, it is very, very tenuous to have a policy on IDEA because there are a lot of cases that interpret it. The IDEA is very specific. But what I see as far as IDEA policy goes is discipline for IDEA students. And the fact that principals sometimes want to confuse, and I say principals for a purpose because principals and assistant principals are literally the only people who are authorized under statute to suspend the child from school. And the superintendents who are on the call, I hope you're not offended by that, but you have no ability under statute to suspend the child from school. Only a principal or assistant principal can do it. And it's once I see the application of the suspension of a special education student, I have to ask, where did you get that? Well, why did you suspend the special education child? Is it a suspension within the 10 days that are allowed under federal law? Is it a suspension? And they say, well, we just put them in the alternative school, nothing's going to happen. Well, that's effectively a change of placement. So if you're following policy there, but one of the things that continually gets confused here, even if you are following the policy, is they view the alternative school as an interim alternative placement. And I'm going to say this in the context, again, of something that's going to come up in just a few minutes. In the realm of threat, if a student has made a threat, an interim alternative placement under special education is not available for a threat. So that 45-day placement for interim alternative purposes is just not available. So if you're assigning them to the alternative school, you're calling it an interim alternative placement, it's not available. It doesn't matter what your policy says. It's not there. And we run into policy considerations with folks who want to act first and then consider the rights of a special education student. But if it involves a threat, those are limited to firearms or weapons under special ed law, weapons to the sale or the solicitation for sale or the possession of controlled substances, or assault that causes serious bodily injury. Those are the only three things for which an interim alternative placement are available under federal law, not a threat. A threat is a zero tolerance offense under state law, so long as it's a valid threat. And we're going to go into that on Tuesday on what the definition of threats actually is. But interim alternative placements are not available for threat. And so don't look to your policy for a resolution for that if threats involve a special education student. Now, Wanda, I may have just set the world on fire with that. But, are there any questions?
Nobody has posted a question.
Okay. I'm just going to mention that briefly, just under IDEA. And most of the policies I look at under for IDEA in the policy manuals, they just basically say we're going to follow the rights and the responsibilities and the procedures that are outlined in the IDEA section, 20 USC section 1400 et sec. That's all the policy you need, because there are plenty of pages of regulation, plenty of pages of law to cover you there. And if you try to, and the state board of education regulations are particularly important in IDEA. We deal with that on a consistent basis with school districts, because the state board rules say, particularly about the substance qualification for being gifted. That literally varies from state to state. There are only 7 or 8 states that have giftedness as a disability. So refer to the state board rules. Don't try to write a policy on that.
Now we have 2 questions. Can you repeat the 3 offenses that you mentioned first? And then the second question you can answer at the same time, I think. Is this threat situation because of the new Tennessee law, or okay?
Yeah, the 3 situations for which interim alternative placements are available under federal law are the possession of weapons on campus. And it's not limited to firearms, it's weapons. So, and there are examples of weapons in the federal law. So it could be a knife that has a blade on it too long. It could be a firearm. It could be something that's used as a weapon. So it's weapons for special education children, not firearms. So again, it's a bit of a broader definition. Weapon, number one. Number two, the possession of, the sale of, or the solicitation or sale of controlled substances on campus. So again, it's broader than state zero tolerance law for special education students. But controlled substances, but it includes possession, the sale, or the solicitation sale. The third for the consideration for an interim alternative placement is bodily injury or serious bodily injury, assault which equals serious bodily injury. Serious bodily injury is defined under the statute. Those are the three things for which an interim alternative placement is available. And the reason I bring this up is I've had about 3 instances this year where we've had a student who's made a special ed student who's made a threat, and they said, "Well, can I want to put them in an interim alternative placement?" I said, you can't. We have to go through the manifestation process. If it's a manifestation of their disability, then they're going back to class on. And that's the toughest pill to swallow, I think. But if it is a manifestation of a known disability or their disability to which we have an IEP, they're going back to class. Secondly, it is interim alternative placements are just not available. Threats are a state zero tolerance offense. Our state legislature has deemed that threats are a zero tolerance offense. And so they don't fall under the federal law. The federal law says interim alternative placements are governed by the federal law, and threats aren't included in it. So if you have a special education student who makes a threat, federal law is going to apply first because we have to make a manifestation determination. Then we treat them, if it's not a manifestation, we treat them like any other non-disabled child, and then the state law kicks in. But the manifestation of the decision comes in first. It's just that interim alternative placements are not available for us. Any other questions? And we're going to go into this in some depth on Tuesday with discipline of regular ed and special education students. And as a highlight of what's going on, we're going to take 2 students to whom we're going to assign some names to, and we're going to follow them through the process. Exactly what has to happen and the differences of what's going to happen for various offenses. Some of which may be not Title IX, but the zero tolerance offenses, some of which are just mischief. What has to happen before we discipline students, and how do alternative schools apply and things like that. So that's a forecast of things to come. Going on with the next section of policy that applies, I'm going to walk over into the wide world of legislation, particularly bills that were passed this past session of the legislature, and talk to you about policy implications resulting from pieces of legislation that passed last year, and the way we ought to be looking at policy, and the things that we have to consider as a result of this last session's legislation. The first thing I want to consider is the conference committee report on House Bill 390 and Senate Bill 191. Many of you recall that is the bill that what we call the remnants of the voucher bill that ended up becoming law. And it's one of those that we try to stress what people can and can't do as a result of this, because there's some policy implications in this. But this is, again, the conference committee met, the legislature adopted the conference committee report, and there's some very specific policy implications there for us. The first one is you must examine your school system's grading policy. your school system's grading policy. Because it says that a minimum grade above 0 cannot be adopted by by school system. So your school board can't say, for example, the minimum grade that any student is going to receive by policy is a 50. And we have school systems all over the state who have that either as a standard practice or in some cases as a policy. Well, the legislature interfered with that. And the legislature just told you what your policy is going to be. It says you can't have a minimum failing grade of above 0 as a policy. Now, let's think outside the box just a minute. That doesn't stop a teacher from having a personal practice of doing it. It doesn't stop him from having a personal practice. But the school board policy cannot state that the minimum failing score will be a 50, for example. That's the teacher's practice can do that. Well, I was always happy for teachers who graded on the curve, because it meant in some cases I survived. But you know, if that's a teacher's practice, that's not school board policy. A formal written policy of a school district cannot create a minimum score of 50 as the minimum failing score. Now, I saw Leah Watkins come away from Henry County, and she has asked her share of questions already, but we'll honor one more. What was her question?
What if our teachers and administrators developed a procedure that any grade below 50 requires administrator approval?
That's fine. It's not school board policy. It's not school board policy. And that's what's very important. Not school board policy, because the language of the act says an LEA shall not create a local grading policy or procedure that establishes a minimum grade above 0 that the student may earn for coursework. Now, why the legislature want to get involved in this is candidly a little beyond me, but nevertheless they did. You know, but it says a procedure, a policy or procedure that establishes created by the school board. That can't be done. If a school or a teacher wants to have that as their personal policy, then that's fine. But it cannot be a published policy in school.
Okay, I'm not sure I understand this question, but I think I do. It says, we thought there was already a State Department approved grading scale that boards had to accept.
There is.
That,
and there is, it's in the state board rules and regulations.
Okay.
Grading scale, but the grading scale was established not to determine minimum, minimum failing score. It was to determine grade ranges for purposes of, say, the Hope Scholarship. It was to standardize grading scales for the Hope Scholarship, qualifications for financial aid and scholarship beyond that. So that's what it was. And that's the reason for which the legislature did it. We have grade scales all over the place. And it was a bit of havoc when this thing called the Hope Scholarship came. So the legislature ordered the state board to standardize the grading scale. What this bill did was take it the other direction, not on the upper end of the scale, the lower end of the scale. You can't have a board policy that establishes that 50 is the minimum, is the maximum, or minimum failing score.
Yeah.
Okay?
That's it.
There is, whoever asked the question, there is that is in the statute, but it's to standardize things for purposes of grades otherwise. The state board shall include in its policy, for example, in its policy procedure, the number of students enrolled in public schools are identified by the school as chronically absent. Chronic absenteeism is one of those things that the legislature is now trying to capture, realizing that we're not in control of a lot of things. So if your policy is in place and it addresses chronic absenteeism, defer to this act. And by the way, this act defines chronic absenteeism as any student who misses 18 days or more. So if you have a policy that's different from that, the state legislature has now told you what your policy has to be in order to consider a student to be chronically absent. So again, again, that's over in it. I'll just read it to you for purposes of subsection G. Chronically absent means a student has been absent for school for 18 or more school days in the school year, not consecutive days, 18 or more days in the school year. And your policy definition of chronically absent should coincide with that. Any questions about that?
Yes. And this goes back to the standard grading scale. If you only have to adopt the standard grading scale if your system has a high school, is that correct?
Yes.
Okay, but the minimum of 50 applies to all grades.
All school.
Okay.
Applies to all school. The next one is one that I hesitate to wander off about, but and it's one of those that I'm just going to tell you candidly. I prefer that you rely on state board rules and on the law to determine fourth grade retention, either third or fourth grade retention, because there's this tendency if we develop local policies on this, local policies will be in conflict with state law, and that's going to catch you. But public chapter number 989, which was lobbied heavily by Toss. Austin was very influential in the process of developing this public chapter. Public chapter 989 is that state law that talks about fourth grade retention. And if you're going to have a policy about retention, it needs to virtually mirror what's in the statute here, either third or fourth grade retention. Third grade from last year, fourth grade from this past legislative session. But you need to have a policy that virtually mirrors that. It needs to be reviewed by your legal counsel. So it is if you're going to have that policy, just make sure that it comports with public chapter 989 about what your decision is to make sure the child is promoted, make sure they have a tutor all year long. Things like that. If you're going to have that policy, it's optional. There's no requirement to have one, but make sure it mirrors the statute. That it mirrors the statute. Any questions about that?
Yeah, we got a couple of questions. One of them, we need to go back to the chronically absent.
Yes.
They want to know this. Are you saying that chronically absent is 18 days per period or 10% of enrolled days? So TDOE currently marks a student chronically absent if we have them 120 days and they miss 12 days.
Well, for the purposes of subsection G, and the act that refers to the number of students enrolled who have been identified by the public school as chronically absent, and what it says for the purposes of that subsection, chronically absent means a student has been absent from school for 18 or more school days of the respective school year. So this act does not refer to 18 out of however many days the person was there. It just says that they're absent for 18 or more days. And and we're trying to get chronic absenteeism removed as one of those markers for which school systems are being graded, which a letter grade is being applied. Now, I'm just going to be candid about this. Whenever we get into definitions of 18 days or 20 days, or however many days they were enrolled, that's something you better get approved by the State Department of Education if you're going to declare that person chronically absent, because they determine that. But for purposes of this act, chronic absenteeism is defined as 18 days or more of absence for that school year.
And I'm seeing if I have a follow-up question, but I do not.
Okay. Again, fourth grade promotion is one of those things that in third or fourth grade promotion, if you have policies on that, I would advise that you don't have policies on that because it gets really convoluted. But in this case, my recommendation is that you just mirror what the law says and make your policy very concise. It does not have to include a lot of options or a lot of other things. If it involves that subject and that subject alone, make sure your policy is concise, clear, and the tracks the law. That's one of those times that I will advise you, if you choose that policy, make sure it says what the law says. The third thing, the third bill that I'm going to take up is Public Chapter number 1061. This act, probably more than any other this year, has caused a lot of heartburn. And it's the Family Rights and Responsibilities Act that passed in the last days of the General Assembly. It was literally the act that passed the next bill that was taken up after the bill that authorized arming of teachers in schools. This bill didn't get a lot of discussion. It got a big vote. It didn't get a lot of discussion. People just accepted the explanation for what it was. The most important thing that I will, well, there are several important things in the bill, but there are three important things that I'm going to take out. Number one is the collection of biometric data. Does anybody know what that is? And if you do, email Wanda, because it has a broad definition. It's much broader than you think, and there's some gotchas in it as far as biometric data goes. And I looked up websites for the Department of Homeland Security. You got biometric data. Ms. Brown, you're exactly right. I looked up the definitions for biometric data from the Secret Service, from Homeland Security, from the Department of Justice, and the Department of State. And what do we consider biometric data? Well, this bill has some definitions in it, but the broader definition of biometric data can be a little bit more encompassing than what we think it is. But in some cases, I'm not sure this was thought through very well when that term was used about the collection of biometric data. But it's what the bill says is if you have a policy of data collection, then your policy says that a parent has to consent to the collection, storing, or sharing of any individual biometric data relative to the analysis of facial expressions, EEGs, brainwave patterns, skin conductance, galvanic skin response, heart rate variability, pulse, blood volume, posture, and eye tracking. Now, that's what the bill includes. Biometric data, according to the other sources that I checked, also includes fingerprint, iris print, voice print, and this is the one that sort of got my attention, handwriting. Handwriting. How many of us have samples of handwriting in school? And how many of us know teachers who can probably pick up a paper that doesn't have a student's name on it, and they can look at the handwriting and go, I know that's check paper. He has worse handwriting in the class. So they can pick that up. And could that be an identifier? And would a parent have to, for example, approve, to give you the far stretch example here, would a parent have to approve the posting of Chuck's paper for open house night if it can be identified by my handwriting? I'm not sure. Again, these bills come to us from sources outside the state who write these things, or special interest groups who write these bills without knowing how school operates. So when I got the handwriting, I sort of raised my eyebrows in a very big way and said, this causes all kinds of problems for us. If this handwriting is ever going to be included in biometric data. But right now, if you have a policy that says we're going to collect some of this stuff, then you need to understand and remember that the bill says that we have to have parental consent collected. We have to collect any sort of biometric data. Now, I don't know of any school system that collects EEG. I'm sorry, I don't know of one. I hope I don't represent one, but I don't think EEGs or brainwave patterns are being collected by schools. I don't know about skin conductance. Somebody in the nursing field would have to tell me about that. Eye tracking, I don't think we do that. We do eye screens, vision screening and hearing screening. Those are not biometric, that's not biometric data. But we do that. But heart rate variability, that may apply more in college than any place else for extreme athletic programs. I don't know of any place for doing that, but if you are doing it, this act does state that in order to collect that data, we have to have parental permission to collect it. Certainly, we would have to have parental permission to release it. Any questions on that?
Yes, two questions. I know that there's companies that currently are allowing us to use the kids' fingerprint to get them access to computers, and even in their lunch program, they use their fingerprint to go through the lunch line. So they're using it for themselves, but we're not really collecting it. Is that okay?
If that would fall, yeah, it's okay to an extent, as long as we can keep that database confidential. Then it's okay. We're collecting it only for our use and for the use probably of the vendor. You know, as long as we can ensure the confidentiality of that data, I think it's fine. Where it's going to be used for any other purpose besides buy lunch or access to computer, if it's going to be used for any other purpose, we get through. And we've established a practice of doing that, which is much more loose than a policy. Then we have to assure parents that it does not get out of our possession.
Okay, then the next one is, we thought this just meant the BMI data that we were asked previously to collect through health, family resource centers, whatever. Does this include BMI data, body mass index data?
It could. Let me just say that this is one of those bills, and I've said this to Dr. Lilly, so I don't think it'll be a surprise to my boss. We're going to have to work on that too, because the bill is so broadly written that literally any interpretation can be made of this thing. Literally any interpretation. And all it takes is one parent who's aggravated enough to make a complaint. And it literally is concerning. I'm quite frank with you. This bill is so broad that I think it can be interpreted any way in the world. And at least one of the sponsors has indicated some willingness to go back and examine some of this. This bill, I think, could be improved out. If you have a parent who's angry and wants to take it to a school board or take it to a lawyer and sue somebody, just say, I didn't give my consent to it, so I don't give my consent to it. And you've now collected it, and I'm upset about it.
Okay, the last question on this is, my nurse thinks biometric data includes taking temperatures. Does she actually have to have parent permission to take a temperature?
No,
Okay.
no. Biometric data doesn't, that may be a record. It's not included under biometric data. Now, if you use, let me give you an exception to that, for example. If you use some sort of heat pattern from a hand, from a palm, to access a door or a computer, that is biometric. But taking somebody's temperature in the nursing station is not biometric. It would not be considered even under as broad as this act is. It would not be considered biometric data.
Okay, here's the last one. Our system does hearing and vision screenings, but we're now being told that we must get parent permission before we do a hearing screening or a vision screening. Is that true under this law?
Yes, it is. And we should have parental permission for that anyway. We're creating a health record there. That's probably, some of that stuff even goes, I've seen it in student records, believe it or not. Particularly in a special ed context where we had a student tested and the parent will pop up and go, I didn't know you went to a vision and hearing screening. When did that happen? When did that happen? Well, we did it, and suddenly we're telling the parent about it. I think the general release that we're sending home ought to be broad enough to cover that. And we'll talk about those releases in a minute. It ought to cover screening devices, even though those are screening devices. They're not medical diagnostic. They're screening.
Got it. That's it.
Okay. Again, with regard to policy, What this act says is nurses are pretty much constrained about what they do. You've heard Dr. Shelton talk about that here. Some of the questions asked about it. This bill was is and was very confusing for school health practitioners, nurses, particularly. And what we say is we've asked parents to sign general releases so nurses can do their job, and so that children aren't injured by a lack of health care. But in cases where students, as far as policy considerations for your school, in cases where students need emergency care, I am all in favor of your policy saying that we're either going to call emergency services to a school if we don't have consent, or the healthcare provider is going to stabilize the student until emergency services can get there. That should be a valid policy consideration. We have had a number of parents, and I'd like, that's maybe an interesting survey question, but we have had a number of parents who have just flat out refused to sign the release, and we literally hope that nothing happens for those children. But the nurses have asked me the question, I say treat the patient, and I'll worry about the liability later. But I don't think your license will allow you to ignore an emergency nurse. That's just not possible. Now, one absolute here that should be in your policy, as a policy consideration, this bill notwithstanding, if we're going to be asked to give prescription medication at school, administer prescription medication of any sort at school, then parental permission is absolutely required. It's absolutely required. Just producing the pill bottle with the protocol on the front of it, with the student, sending it to school with the student, that's not enough anymore. If we're going to administer that medication, we need parental permission. If the parent will not give us permission, we have the obligation under law now to say we will not administer this medication at school until you give us the release. And that should be in your policy. That should be a policy consideration as a result of this very bill, to state that all prescription medications that we administer will be done so under this set of circumstances. Number one, in a medicine bottle with a protocol on the front of it, but with parental permission. We have to have the parental permission signed. Any questions about that? And we've got some parents who are not used to that, though. We're just not used to it. They're used to bringing those prescriptions to school, and we just hand them out. That now has to be done with a signed parental permission. Any questions, Dr. Shelton,
Yes.
at all?
They just came in. Hang on just a second. How does the emergency administration of an EpiPen for children not previously identified as needing it fall, since that is currently part of our legal requirement?
I think that if it's truly an emergency, if somebody has made a decision that it is an emergency situation, even particularly a nurse, they've made that decision, administer the EpiPen, and then again, it's like Title IX. We're just going to report it to a parent in an emergency. If this was an emergency, your child was having problems that necessitated the administration of epinephrine, and we're now reporting it to you. And if you want to sign that parental permission, we're happy to take it. But my opinion is, first, do no harm. Don't let that child suffer or die, because we're standing around wringing our hands because we don't have parental permission.
So the emergency treatment does not actually restrict a nurse's ability to act under this law. Is that?
Here's what I think. The nurse has a responsibility under their license to act. That is where this law conflicts with the practice of healthcare. A nurse or a doctor, a healthcare professional, has an affirmative duty under their license statute to aid and assist, a person who is in need of those services within the scope of their license. So there are certain things nurses can do and can't do, but as long as is within the scope of their license, and as long as they're practicing according to what are known as community standards, they have a duty to do. So how in the world can we tell a nurse you can't save a life for lack of a right? Because that goes against their practice. That's again one of those things that we're going to have to fix in the coming session of the General Assembly, and that's the define situation that this bill doesn't define. By saying that a parent just has an absolute right. Well, if I can't get in touch with the parent, or the parent won't pick up the phone, which is the incident I dealt with last week, they won't pick up the phone, or the school finally does get through to them, and the parent is, is all over the place. The whole time the child's suffering. What do we do? What do we do?
And the last part here, are school nurses bound by a do not resuscitate ruling if families have a child that has severe medical concerns? How does the school fit into a DNR? Here's
Chuck Cagle on the law, and this is my opinion, and it's worth exactly whatever Wanda charges for it. So I'm just going to give it to you. We don't make those decisions. DNR decisions are not made in school clinics. DNR decisions are made by physicians. When the physician says that the person's life is not viable, given standard care, then that physician makes that decision. We don't make those decisions at school, and that's been my position. That's been my position for years. We will call an ambulance. We'll let your paramedic make those decisions, but we don't make those decisions at school. Because as sure as the parents sign a DNR and it comes to school and that child dies, that parent's going to sue. That parent's going to sue.
I think I've got.
We are professional medical providers will make that decision. Nurses don't make that decision at school. That's not in my opinion, that's not a nursing decision. That is a physician decision and to comply with the DNR.
Okay, I think I've got this one right. One of our schools is more than 20 minutes from the local hospital. If a student breaks their arm, is it, no matter what the parent has agreed to, can we still call 911 to get an ambulance?
Yeah, that's always an option. Calling 911 is always an option. Particularly in cases where parents won't sign the release. As many of you have heard me say 1,000, 10,000 times, I've called parents and said, let me tell you what's about to happen to you. You're going to pay for an ambulance if you won't sign the release. Now, can a nurse stabilize the student until the paramedics or the emergency services get there? The answer to that question is yes. If that child has a break that, for example, has perforated the skin, and you've got a bone sticking out, the child's bleeding, can they stabilize the student? The answer is yes, they can do that. If the parent will not allow us to administer aid and assistance, then we stabilize and call the paramedic.
That's it on that topic. Thank you, Chuck.
That's again, that's one of those things that we need to fix. We need to sit down and have a general discussion about this bill and remind legislators how school works. That some of our clinics are the equivalent of a mini trauma unit. There's serious medical attention given to students in some of these nursing states. The third bill that I do want to talk about a bit is your policy on threat. We've had there's been a lot of interesting discussion about how the threat laws correspond with each other. And to some extent, they are in conflict with each other because we have threats that are addressed in Title 49 of the code, which is the education portion of the code. We have threats that are defined in Title 39 of the code, which is the criminal law and the criminal procedure part of the code. So in a lot of cases, there are just some very different things that we have to do. And I'm going to try to make some sense out of this. The first is, if you're going to write a policy about what is a threat of mass violence, I think you have to have a definition of what is a threat of mass violence. What is that? Without a definition, the policy is going to be meaningless, and it's going to be subject to random interpretation and probably random enforcement. So as long as we remain in the policy mode here, if you're going to have a policy about threats of mass violence, then somebody better define what it is. If your policy is absent that, it's probably not going to. It's probably going to be found not enforceable. Under 3916.517, the threat of mass violence is defined as any act which a reasonable person would conclude could lead to serious bodily injury or death of two or more persons. I'm going to say that again. 3916.517. Mass violence is defined as an act which a reasonable person would conclude could lead to serious bodily injury or death of two or more persons. Now that's a statutory definition. A serious bodily injury defined in 3911.106 as any bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, protracted loss or substantial impairment of a function or a bodily member, organ, or mental faculty, a broken bone of a child who is less than 12 years old, or 12 years old or less. Those are the other definitions. So you can include all of that into one definition, but you're going to have to define what is a threat of mass violence. Now, let's just put this practically. How many of you have punished children for threats of mass violence this year and it doesn't fall under that definition? And I'm not going to ask for a show of hands, but folks, everything out there, every excited utterance of a child is not a threat of mass violence. Let me just say that for policy consideration, you're going to define a threat of mass violence, then it needs to be statutory. And every excited utterance on the part of a child that occurs on a playground is who says something like, "I'm just going to kill everybody." That is not a threat of mass violence. We've got to get past that. As far as threat, one of your most important groups to utilize is the threat assessment team, which we have acronym that's operational around this office is PAT, the threat assessment team. And on that threat assessment team, we regularly include members or representatives from Homeland Security, and we also regularly include SROs. Why do we do that? Well, as a matter of practice, maybe not policy, SROs can do things you can't do, like go to a home where a threat of mass violence has been produced by a student. SRO can go to the home. They can actually ask the parents, does this child have access to weapons? And can we see that those weapons are secure? And then ask, are they secured? And can we see how they're secured? SROs can do that. School officials can't do that. So a threat assessment team is important, but the players on that threat assessment team are of equal importance. Who's on the team? Well, your SRO and maybe a member of Homeland Security, your local Homeland Security rep may want to be at least one of those positions on a threat assessment team. Tennessee Code Annotated 49.6.2701 for policy purposes states that the purpose of the threat assessment team is to develop a comprehensive intervention-based approach to prevent violence. That's number one. So threat assessment teams are supposed to come up with plans on how we prevent violence. They're to manage reports of potential threats. How do we respond to potential threats? And then create a system that fosters a safe, supportive, and effective school environment. Right there is your introduction to your policy. Straight out of the statute. What does the threat assessment do? The team do? Well, that's your introduction to your procedural policy. The threat assessment team must include LEA personnel, law enforcement personnel, but also may include the following people: juvenile services personnel, a representative of the district attorney general's office. Now, I kind of prefer we don't do that because that gets them involved in the investigation of what may end up with prosecution. A representative of the Department of Children's Services and the Mental Health Services provider. You can put all those people on your threat assessment team. But in the minimum, it should be school personnel and law enforcement of some sort. So as I said, those questions can be asked. Charter schools are also bound by this. So for any charter schools that are represented in today's call, you're bound by all of this for your threat assessment team. The threat assessment team has to make sure that the documentation is complete. That should be in your policy with regard to threat. So we're going to keep a complete set of records on every one of these things that we investigate. Particularly if it has a substantial chance of posing a risk to school safety that resulted in some sort of intervention. We need a good report of that. And sometimes training, and I would put in the policy that training will be produced annually for those members who serve on the threat assessment team. And record keeping would be part of that threat assessment. So that should be required. I've got copies of school board policies that we've already referenced here in Tennessee. Metro Davidson County, for example, has a good policy on how we train the threat assessment team and what their function is. The preliminary determination upon the threat assessment team preliminary determination of an individual poses a threat of violence or the significantly disruptive behavior. The team may request law enforcement information and records and court files and records. So the threat assessment team has access to a lot of information. That should be in our policy, that once we have that determination, the threat assessment team will access those records. If they exist, they will access those records so we know exactly what we're dealing with. The type of individual and exactly what their activities have been in the past. Rather than saying that they have access, our policy, my recommendation that your threat assessment team policy should say we will access those records. We will access those records. It's just a matter of standard protocol. And it says that your members of your threat assessment team are immune from any liability. That's a mistake. Now, the next part of your policy is when do we have to report threats to law enforcement? And there's folks, I'm just going to tell you, there's vast disagreement about this across the state. Some groups say you have to report it to us every time. Every time you get a complaint of a threat, you got to report it to various individuals. Other groups are saying that we want to follow the law. Other groups are making it up as they go. Well, you should have reported that. We're getting a lot of that from some areas in the state with law enforcement. They're saying you should have reported that. We're finding that the statute is pretty consistent on when you shall report. If district attorneys general, for example, want to be included in this, then they just need to tell us in writing that they want to be included in all of it. The general rule is that any person with knowledge of a threat of mass violence on school property or a school-related activity, whether valid or not, must immediately report the threat to law enforcement, and that school is subject to, and that the school that is subject to a threat of mass violence, if it's under 3916.517. So anytime we get the knowledge of a threat, we have to report that to law enforcement. That's under Title 39 of the code. However, if we have knowledge of a threat of mass violence on school property, or school-related activity that's made by a student, then the school must immediately report the threat to law enforcement only if the threat is determined to be valid. So there's discrepancy between Title 39 and Title 49 of when a school has to do this. In my opinion, we default to Title 39. Let them decide whether it's valid or not. We're going to go ahead and assemble the threat assessment team to see if there's student discipline that can be applied here. Let them report it to law enforcement make a determination about whether there is an offense for which the child could be prosecuted either in the juvenile courts or the criminal court for it. There's a difference in our function. The district attorneys general and law enforcement are interested in what can be prosecuted downtown. Our threat assessment team is going to be engaged in this process under Title 49 to determine what we can do on campus. Can we punish the child on campus for behavior that's threatening? Is it possible the child can be punished both places? The answer is yes. Yes. But our objectives are very different. Our objectives are very different. So the DAs and law enforcement are going to be interested in downtown. We're going to be interested in on-school campus and what happens under school board rules. Our policy. What security measures can schools take when receiving a threat of mass violence? Well, if a student threatens mass violence on school property or school-related activity, then the school must require the student to submit to a threat assessment to determine whether the student's threat was valid. That should be in your policy. If you make a threat, then you must submit to a threat assessment to make sure that so we can make sure whether this is a valid policy or not. Is there any question about that?
I've got a couple of questions. The first one is, I think this new policy under 49 states that the minimum number of members for this threat assessment is 2, the SRO and the principal. But in the safety training we've been having this semester, there's been a lot of suggested members. Should you put in your policy who's going to serve on each school's committee?
I don't think I would commit to a number
Okay.
because I think it's kind of like an IEP. You don't have a speech pathologist on an IEP team if a student doesn't have speech problems. So think of it as an IEP. Who are the proper people to have here? Probably law enforcement, because again they can ask questions and do things that we can't. School officials with just good, reasonable, clear-thinking school officials. Number 2, maybe a school psychologist, maybe a school counselor, somebody like that, who can also have some input here. Maybe a health professional. Maybe you want the nurse there. So I think I would construct the proper team and not based on the circumstance. I'll say this again. We'll construct the proper team based on the circumstance and not be stuck to a number. I would probably stay away from just the principal and the SRO.
Yes, me too. That would be Wanda's recommendation as well, having done threat assessments for a long time. The second question, Chuck, this year, we've had no problem at all investigating the situations where a student made a threat, but we don't know exactly how this law falls into the international threats we're getting, the threats that may come through TikTok or YouTube or Instagram from foreign countries, but they're saying things like, we're going to blow up your school at 9 o'clock. How does all this work together?
It doesn't. Those are incidents that fall completely within the realm of law enforcement. If that student's not under our jurisdiction, if that person is not under your local school system jurisdiction, then this policy doesn't apply. It falls completely within the realm of law enforcement and threat assessments. They fall to even the Homeland Security or somebody like that. But there's nothing. For instance, if a child in the Netherlands decides he's going to send Moore County High School a threat, there's absolutely nothing we can do that for. Nothing. We have to take the threat seriously. We should report it to law enforcement. Absolutely, that should be in your policy. I would state to you that should be a necessary component of your policy. That we're going to take all threats and report them to law enforcement, particularly those that come from outside our jurisdiction.
Okay, and then this is just an aside. On December 4th this year, we're going to have a national Homeland Security presenter on threat. We're going to have a state of Tennessee Homeland Security person, And then we're gonna have a couple of other people that have been working with Homeland Security reporting. So if that question came from you, you might want to sign up for December 4th.
That's the Toss ALI program?
It is.
Wow, okay. I may have to be there. That
We're
sounds-
welcome you.
That sounds, I'll even pay the price of admission. That sounds good deal. Thanks for that. Thanks for that. Really, it's, we have to deal with a lot of those. And folks, some of those folks have compelling stories. Let me just tell you, they have compelling stories about threats that could affect schools that you think could never happen in your community. Let me just tell you that they're there. The U.S. Department of Justice, the Secret Service, and the FBI have all provided informative resources on the prevention, preparation, and responses for threats of mass violence. And I've looked at a lot of this stuff, and folks, I'm going to tell you, there's a lot of good information out there for the formulation of policy. And this is one of those things that I think a policy committee should sit down and take a look at, particularly with regard to Homeland Security and the Secret Service. They've produced some very fine documentation on just patterns, things you should be looking for. So things that go on in school that should get your interest about possible threats of mass violence. And it's one of those things again that I think you ought to pay attention to. What are schools reporting responsibilities regarding other incidents of student misconduct? Well, 49.6.4301 says that any teacher, basically it says teacher, but any school employee who observes or otherwise has knowledge of an assault and battery or an act of vandalism, endangering life, health, or safety committed by a student must immediately report that to the school principal. So that should be in your policy. Even if it's not a threat of mass violence, if a school employee notices an act that endangers life, health, or safety committed by a student, then it's their duty to report that to the principal of the school. And it's not, and again, with all the school superintendents out there are my best friends, but it's not the school superintendent, it's the principal of the school. That person is the person with the power to discipline that child. Now, getting it to the superintendent is sufficient as long as the superintendent turns it over to the principal or to the threat assessment team. But the primary responsibility for investigating these things is either going to be the threat assessment team or the school principal. And the 49.6.4301 talks about school fight. And it says that the Court of Appeals has held that any fight or assault not involving the use of a weapon or not resulting in serious personal injury does not have to be reported to law enforcement. That's Kendrick versus the Board of Education in a case that was decided in 1996. Now, law enforcement is taking that a different direction. And we had a case in Tennessee in which I was involved where law enforcement completely took that a very different direction, said you must report that to us. Well, we've got a Court of Appeals opinion that says no, we don't. And the law on fights in that regard has not changed. That's where the fight does not cause serious personal injury. If it does cause serious personal injury, there is a statutory duty to report it to law enforcement. So if you got, we've had to deal with those stabbings, fights of all sorts, the fights that involve a serious bodily injury, those must be reported to law enforcement under the statute. But just a general common fight where two guys getting shoved and matched, that does not have to be involved law enforcement. And all zero tolerance offenses under school board policies, I think your policy should state that all those are going to be reported to law enforcement, and they're also going to be reported to the parent immediately, the parent or guardian. But more importantly, if you have a zero tolerance offense that involves a gun, which is firearms, is the standard zero tolerance offense, or it involves controlled substances that you confiscate, you have to turn the contraband over to law enforcement. So your policy should say that all contraband that's confiscated in a zero tolerance offense, if it's firearm, if it's marijuana or pills of some sort, or prescription medications that a child is not in legal possession of, then those will be turned over to law enforcement. The funny story, I ran in several years ago, I ran into a situation in the school district I represent where they confiscated a quantity of marijuana on a Friday about 1 o'clock in the afternoon. And on Monday, I was called as the school board attorney about a zero tolerance offense. And I just casually asked the question, what happened to the marijuana? And they said, oh, it's here in the school safe. And I sort of said, well, what did y'all do? Have a party over the weekend? Turn that contraband over to law enforcement, establish a chain of custody for it. We don't keep stuff like that in the safe. We don't keep random firearms that we take up from students or other folks on property, school property. We don't keep those in school safe. We turn them over to law enforcement so that the chain of custody can be established.
Does that include paraphernalia, Chuck, pipes, whatever?
Yes, I want law enforcement. A chain of custody is a law enforcement company. Once we confiscate evidence, once law enforcement confiscates evidence, then they have to know exactly where that evidence went, what happened to it, if it was tested, who tested it, what the test results were. They have to know all that. That is a law enforcement term, and that's exactly what we want to establish with contraband on campus is some sort of a chain of custody. And yes, I have called a sheriff's deputy or an SRO into a student disciplinary hearing and have been testified about the contraband and what it was, and where it's kept, and the fact that the chain of custody, that records are being kept on. I've gotten affidavit, and I've also gotten affidavits in those cases in certain periods. So just be aware that it should be our policy that any contraband found on campus, parenthesis to include weapons and controlled substances in parenthesis, will be turned immediately over to law enforcement. And of course, once you turn it over to them, they have the power of prosecution at that point. So that's notifying law enforcement and handing them the evidence. But we have standard agreements with law enforcement to do that. That should be in your policy. Any questions? That's it. Well, I am out of paper, so everybody gets credit for an extra hour or so here of fun. I'm gonna get in trouble one.
No, they like that, Chuck. That will be no problem.
Let me just go back to where I started to say that when it gets to policy, we can talk about all kinds of issues. And I see another one come in, but I'll get to that question in a minute. Right now, if you have questions about any topic, get them to Wanda in the chat, and I'll answer questions about any topic. Your school board policies are divided, policy manuals are divided into 6 or 7 different headings. I can't tell you the importance of those policy manuals. I consult them every day in my practice. If I write you a letter that concerns an issue or an email that concerns an issue, in 99% of the cases, I will have consulted the policy manual and I will cite you to your own policy. It's just in some of these cases now, it's getting very important, particularly with regard to threat, that we just don't say that an excited utterance or a careless utterance on the part of a third grader is a threat of mass violence. We actually have to step back now. The law requires that we step back and make an assessment of that. And some of them, folks, with all due respect, are not going to be punishable by a year in an alternative school. It's just not going to happen. The law, and let me just tell you a case of a lesson we learned from a case called Field versus Dunaway. It's a case out of the Sixth Circuit, and that case can be summarized in one line: having a good policy does not relieve you of the obligation to think. I'm going to say it again. Having a good policy does not relieve you of the obligation to think. You're still required to apply the policy and the facts to any circumstance and reach a reasoned conclusion in every circumstance. So you don't get to just hide behind the policy. Our policy says this is what's going to happen. Think about it. Listen to the facts, because I can tell you in Field versus Dunaway, the facts will not make attention to. And the Sixth Circuit was very chastised the school district in this state severely for it. So just be aware of that. apply some common sense to your policy enforcement, decision.
Okay, I
Okay.
have a couple. Are there any state board policies or requirements as far as coding students as dropouts after prolonged absences? Is there an age level? For example, could a child, could a school, wait a minute, I lost. Yeah, could a school code a child under 18 as a dropout based on absenteeism? The child simply is not attending.
Have we gone through, trying to ascertain whether that's fact dependent. Have we gone through trying to ascertain whether the child is still in our district? Have we gone through the truancy process with the child, whatever that is? And you should have it. That's one of the more important policies in your manual is how we go through about attendance enforcement in a school system. Have we exercised our rights under that policy to both either campus court or truancy petitions to juvenile court? If the child's no longer in our school district, then they are a dropout. So that's the first question we have to decide. Or has the parent decided to go to homeschool and just not informed?
Yeah, that was the one that took me the most time to investigate. Was a parent would think they had put them in homeschool, but they had never signed the paper, told us.
So
Yeah.
it's all fact dependent upon our enforcement, but I would never just label a child a dropout based on the number of days of absence. I think our responsibility goes further than that. It's the school board's responsibility and pursuant to law, and it should be your policy to enforce the compulsory attendance laws. If we haven't done that, then we jumped the gun by just declaring a child a dropout without seeing if they're still here or if they've got signed up homeschool or what's happening.
In regard to policy regarding parent notifications on surveys, are career assessments excluded?
I think they are. Surveys generally refer to psychological surveys, things like that. And there's even federal law on such things as that. But career assessments generally are not covered under that. Those are, it's a survey and it's not up for analysis pretty much. It's an interest survey. What are you interested in? And there's really not a lot of psychological component to all those, even though some agencies will tell you that they're due. If you have somebody who comes in and wants to conduct a survey and they tell you that there are psychological implications, then you do have to get permission for that.
Okay. Our elementary schools have basketball teams after school. And during one of those elementary basketball teams, a student who was a special education student got in a fight with a student and with their parent. The SRO officer was there, as well as the school principal. The SPED student, was kicked off the team, and now the parent wants a manifestation meeting. And that rule reversed because the adults did not use de-escalation techniques that are in the IEP. Is this applicable since it's not a TSSAA sport and it was not during the school day?
Is it a school sponsored team? And I think that's Toby's question. If it's a school sponsored team, if we're going to remove the child from the team, we should have government manifestation training.
But if it was just like a community team that the school used.
That's right. If it's a community team, then no, we should not have done that. But again, the SRO and the principal should not have been involved in it further, other than just to break up the fight. Keep peace on the school property. But if it's a community team, then some coach who's not a school employee, hopefully, is making the decision to move the child from the school. But if it's a school-sponsored team that's practicing after school, all the procedural safeguards and 20 USC section 1415, all the procedural safeguards apply to that activity. Substitute, and going a little further, substitute special ed student in an after-school care program. The Office of Civil Rights has weighed in on that, saying that if we're going to remove a child, special ed child, from an after-care program that's sponsored by the school, or we even provide the facility for it, we have to go through all the procedural safeguards.
Although, let me ask, I guess this is a follow-up. Even if it's determined to be a manifestation, that doesn't, you can have the meeting without necessarily getting the kid back on the team. Is that right?
Well, I'm not gonna say that.
Okay, okay.
I think it's going to be very fact dependent. There's not going to be a bright line answer for that one. It's going to be very fact dependent upon whatever happened and you know, between the parties. Number one, what was the kid's reaction? There were no de-escalation procedures. And if it is a manifestation, if it was a manifestation of child's disability, then let's have that chat and make all that determination together. The answer is, you know, it may restore the child to the team or not.
Yes,
So it's going to be very fact dependent.
This question, I think, goes back to the Title IX things you were doing. Is there, if it's not in your policy, is there a specific amount of time required for the investigation?
Deliberate indifference has been interpreted very, very broadly by the court. They know what it is. They just don't know how to define it. And for example, we get a report at 4 o'clock on Friday afternoon of some sort of discriminatory activity that falls under Title IX. Are we required to start the investigation at 4 o'clock on Friday when nobody's at school? The answer is no. Was it okay that in this case, was it okay that the investigation began Tuesday morning? Yeah, that the court found that to be reasonable because the parties didn't have any contact with each other over the weekend. Christmas party. You know, and how do we exercise deliberate? How do we exercise, you know, all due speed, deliberate speed rather than deliberate indifference? How do we exercise deliberate indifference on the last day of school when nobody's there? So the court's going to look at each circumstance and make a determination about whether you put it off. Now, I will say it is my personal opinion that those investigations ought to be started unless there's a reasonable explanation for it. We ought to at least document the time that we received the complaint, and if we didn't start that investigation within 36 hours, we ought to be able to tell somebody why. Could have been summer break. It could have been winter break, fall break, spring break. The fact that the complaining party is absent and we could not get a more detailed statement about it. But what your documentation is more important there than the time. When did we get the report? When did we start the investigation? Why did it start then? And the answer to the second question may be answered the third. But you know, if there's significant delay, then we need to explain it. Why there was